We open with Monique Renee Riley Williams already on deferred adjudication for deadly conduct with a firearm. Today the court's focus, a single missed drug test sounds small, but in probation world, one slip can trigger a decade in prison.
All right, court is calling 2021 CR 11076, State of Texas versus Monique Renee Riley Williams. Could I have parties announced for the record for the state?
Zach Dunn for the state.
Charles Buck from Ms. Riley Williams.
And are you Miss Williams?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilty and Revoke Community Supervision with your attorney? Did you understand it? Are you the same Monique Renee Riley Williams who was placed on deferred adjudication in 2021 CR 11076 for the offense of deadly conduct firearm on July 11, 2022 for a period of 10 years? Is that you?
Yes, ma'am.
All right, state.
In Bexar County, Texas, the defendant, Monique Renee Riley Williams, then and there failed to submit to drug testing for the month of March 2024 as directed by the court officer, supervision officer, and or duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
True.
Your Honor, the state waives and abandons the other conditions.
Any objection?
No, Judge.
Did you understand by pleading true to violation of condition number 2, the court can find it true, grant the motion, find you guilty, sentence you to 10 years in prison?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 2?
Yes, ma'am.
Court is going to find violation of condition number 2 true. Is there a proposed agreement?
There is a proposal, Your Honor, yes.
And what is that proposed agreement?
The proposed agreement is to follow the recommendation of probation, which is amend conditions for continued CPS compliance.
Here's where it gets deeper. The court wants no contact between Monique and her child's father until he requests it in writing. That's not just a rule, it's a serious safeguard, usually triggered by past conflict CPS concerns or potential danger.
BIT class completion and a no harmful or injurious contact with the defendant's child's father.
And what's the name of the father?
Jarrell Sinquist.
Darrell what?
Jarrell Sinquist.
Spell the first name.
Jorel, Sinquiz, Senquiz. Yes, please.
All right, why are you not, you want to raise your right hand for me, please?
Yes, ma'am.
Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, state your name for the record.
Monique Riley Williams.
Why are you not being successful on this probation? You're supposed to report for UAs, you're not doing it. Why not?
I missed this one. I'm going to be completely honest. I had forgotten. I don't do drugs or alcohol. I've never came out dirty. So I did ask him to if I can do one that week and he told me yes. So I did 2 for the next month.
All right, is that correct, probation, that you did 2 for the next month?
Yes.
All right, if you need to get a calendar, you're going to have to get a calendar. You're looking at 10 years in prison.
Yes, ma'am.
You understand?
Yes, ma'am.
All right. Any other recommendations?
No, Your Honor, that's the entirety of the proposed recommendations, Your Honor.
All right, I can tell you with regards to Jorel Sinquez, I'm not going to do a no harmful or injurious contact until he provides a letter to probation or comes and tells the court that he wants to have contact with you. There's a reason why people are asking for no harmful or injurious contact. So the court is going to deny the motion, alter and amend conditions to include CPS compliance, the BIPP course, and there's to be no contact with Jorel Sinquez. And if there's an issue, obviously there is an issue because it's CPS, so there's a child involved. If there's an issue with child exchange while the CPS case is pending, they can help make that happen without your contacting him. You are not to have contact with him. Do you understand?
Yes, ma'am.
That means no phone calls, no letters, no, I'm sorry, no, let's try to work this out. No, what's happening? Do you understand?
Yes, ma'am.
All right. Is there anything else you need from the court?
No, ma'am.
Probation, is there anything else she needs?
No, Your Honor.
All right, we can go off the record. Here's just some side advice that I used to always tell my clients on CPS. When you break up with somebody and you are no longer together,
Judge Boyd is giving more than a ruling. She's giving life advice. She's warning Monique about the emotional landmines that happen during child exchanges, especially when new partners get involved in family law. Those moments often spark explosive conflicts.
They may tend to bring other partners in your child's life that they should not be. What you need to do is contact your attorney, or in your case, contact CPS. But you are not supposed to be putting your 2 cents in that relationship. And whatever you do, if this no contact order is ever lifted and you all are doing child exchanges, don't bring your significant other to the child exchange. And if they bring their significant other to the child exchange, just bite your lip and accept it.
Yes, ma'am.
Because crazy things end up happening when people are bringing girlfriends and boyfriends who really have nothing to do with nothing to a child exchange. Do you understand?
Yes, ma'am.
All right, good luck to you.
Judge, she did want to ask, she's got her diploma. And she
Ah.
wanted to ask if that would help with her community service.
Yes, let me see. This is
I'm enrolled
awesome.
in college.
And she starts college in August.
Oh, yes, of course that will help. This is great. You know, I ended up going to Booker T. Washington High School.
Yes, ma'am.
The other schools that had more money than our school had, they did not have the leather binding. And my mom would tell people, hey, where's your leather binding? My daughter has leather binding. But, oh, this is so awesome. I'm very proud of you.
Thank you.
And so what are you going to study? What are you doing in college?
Phlebotomy, hopefully.
Okay, awesome. I can't do that. Don't like the sight of blood, but all right. Well, good luck to you. Just keep striving. And sometimes when you're striving to do different things and better yourself, it's difficult. It gets hard, but don't lose sight of what your hopes and dreams are. Just keep pushing it. Even though the days are long, at some point you're going to reach, your degree.
Yeah.
And then you're going to look back on it and you're going to say, that wasn't so bad.
Yeah.
Congratulations.
Thank you so much.
All right. And probation. She's going to go to college. When she goes to college, community service hours will be deemed satisfied.
Yes, sir.
Defense.
Nick Aguilar on behalf of Monique Williams.
All right. And are you Miss Williams?
Yes, ma'am.
All right. Defense is here requesting a bond. And this case number, she's on deferred adjudication. She's entitled to a bond. Have you all come to an agreement?
Yes, we have, Your Honor. Or
We have
recommended something.
All right.
They recommended a 40 and I anticipated that it would be a 40 and informing the family based on the circumstances.
So are you all in agreement then?
Yes.
Yes, Your Honor.
All right. The court is aware of the defendant's history based upon the fact that she's on deferred adjudication in this court. So therefore, the court is aware of any mental health and medical issues. The court will set the bond at $40,000. The court is going to order partial GPS, waive fees. And I'm assuming she's in yellow because she's expecting. Is that correct?
Yes, Judge, she's expecting in May. And I understand it's, she just used the word high risk.
Okay. So it'll be partial GPS, waive fees, and that'll be for medical appointments.
And then she's also a student at Palo Alto.
Is she going to be continue doing that? Well, is she enrolled currently?
She's enrolled. She turned herself in on this matter Monday afternoon and hope to get this, get in and get a bond set so that she could continue at school and help apartments.
All
She
right.
did not wait to get picked up. She turned herself in.
All right. Do you have any objections to the court allowing her to attend classes?
No.
All right. All right. For medical appointments in school. Is there anything else?
And of course, we can get attorney visits, right? To the attorney office.
Oh, that goes without saying.
Sure.
If they want me to add that, that would be very strange.
That would be very strange.
All right. Let me give you a setting.
Daughter's visit.
Oh, she has court next Wednesday, Tuesday or Wednesday. It's an official court setting with CPS.
Okay.
There shouldn't be any problem with that either. Right?
No, they'll let her go to court.
Yeah. She just wanted to make double sure.
Yeah. So I'm gonna recall this back for October 17th.
Thank you, Judge.
All right, I'm sorry, could you give me a reset for this for October 17th?
Yes.
All right, thank you. All right, is there anything else?
Nothing else, Your Honor.
All
Thank
right,
you
and
very
I'll
much.
add in here for court dates. And
Understand. She was just
it
being
shouldn't be a
cautious.
problem, but I'll add it just in case.
Thank you.
All right, you're welcome.
Get back to the jail.
Why are we filing this motion to withdraw? State, why is the motion to withdraw being filed?
I did present the question
Yes.
to the state. It's due number one, Judge, they're not indicted. One's family violence, that's going to be dismissed, my understanding. But there's two other ones that are ag assaults, have not been indicted. I did inform the defense that we may refile, but at this point, we can't be proving it on an MTR.
All right, and where are you working? Why do you have this badge on?
This is Monique's fourth motion to revoke probation that's a red flag. By now, judges often run out of patience, and prison time becomes a very real possibility. Notice Judge Boyd's tone. She's making it crystal clear that gender won't spare you from prison.
It's a school thing.
I'm sorry?
It's a school. It's for school.
Oh, okay. Because I was like, I hope that's not a badge for a home health care provider because I don't allow that.
No, it's a school thing. It's at St. I think it's at St. Philip's, Palo Alto. I was wrong.
All right. So they're filing this motion to withdraw basically because your cases haven't been indicted yet. This is your fourth MTR that has been filed against you. I don't know what your problem is, but what I do know is the charge you have, you're looking at 10 years in the prison. So if you want to continue on this path, I'm going to tell you what I told everybody else. Just because you're a woman does not mean that they don't have a place for you at the prison. They will make room. And if there are only supposed to be 10 people in a cell, I guarantee you, they're not going to let you run around out here and saying, oh, federal law says only 10 people can be in a cell. So we're just going to let people run amok. They will find and squeeze you into that cell or either leave you in processing. Do you understand?
Yes, ma'am.
Do not come back here with nonsense before this court. Do you understand?
Yes, ma'am.
And these new number ones, who are the complainants?
They're non-family, Judge.
I can find out, Judge.
All right.
Here we see a rare legal win for Monique. The court approves supervised CPS visits with her children despite her being on partial house arrest with GPS monitoring. That's an exception judges only grant when it's in the child's best interest.
Because she's not having contact with those persons.
Yeah, we have no contact with them now. That was part of the bond conditions on these new charges.
Right. So the family violence, the VPO case arose out of the Agasol cases, but because the Agasol cases are not family violence, the elements of VPO are not taxed, which is why it's getting deducted.
Okay.
And Judge, as a condition of her MTR bond and the ag assault bond, she's on partial house arrest GPS. She does have a CPS case open where she gets supervised visits with her child through CPS at the CPS office. It's like on a Wednesday, every Wednesday. If you could approve Miss Williams attending the CPS office to visit her child, her children. And then it might be a stretch to ask, but I'm going to anyway. If she could also take part in any doctor appointments or medical appointments for the children.
Well, once that happens, she can come forward and ask. Because unless the children have some sort of chronic issue, usually those appointments are scheduled.
Sure, sure.
State, do you have any objections to her being allowed to attend child visitation with CPS supervision? All right. All right, I'll sign the motion to withdraw.
The takeaway deferred adjudication gives you a second chance, but every violation stacks the odds against you. Monique's still holding on to her freedom, but the margin for error is razor thin. Next time, there may be no warning.
And counsel, you'll need to, write an order with regards to this, child visitation.
Sure.
Is there anything else?
No, Your Honor. We appreciate your time.
All right, thank you.
They would be excused.
Once you speak with probation.
Judge, so
Oh, and probation, is there anything you want added?
that I'm fully aware, did you amend any conditions?
No, the only thing that she's allowed, she's still going to be on GPS.
I don't have her on GPS with probation.
Oh, it's through, her bond.
So the new cases are not going to move forward. She won't be on
Oh,
GPS,
no.
correct?
No, the new cases are moving forward. They just haven't indicted them yet.
Okay. Okay, Judge.
All right.
I don't have
So,
any other questions.
all right, thank you.
And then I'll be back with an order, probably Monday.
Thank you,
If you just want to write something on the sheet of paper, you can.
Thank you.
All right, thank you.